In this episode, we will be discussing strikes and lockouts. In taking the bar examination, one must take notice of instances wherein strikes will be considered unlawful or illegal. The first in mind would be the means and method. It is clear that when the unions conduct a strike, it is important that the means and method that they employ are lawful. The moment that the means and method that they employ would be considered unlawful, then it will render the strike as illegal. Note that there is a doctrine as provided for in the decisions of the Supreme Court as isolated acts doctrine, wherein only a few members of the union would commit the unlawful or illegal acts. In such a situation, the entire strike will not be considered illegal, but only those members who are committing the prohibited or wrongful acts will be considered as committing an illegal action. The second item that we should consider would be injunction. There are certain industries when strikes are conducted or lockouts are declared that they are considered indispensable to the national interest. In situations like this, the Secretary of Labor may assume jurisdiction of the case or certify the matter before the National Labor Relations Commission for arbitration. Note that the moment that the Secretary of Labor assumes jurisdiction or certify the matter to NLRC, the employees are required to automatically return to work and the employer is required to automatically accept them. If they do not return to work, the strike will be considered illegal or the lockout will be considered illegal. And those employees who are not returning will be considered committing an illegal act. The next item to consider would be agreement. It is possible that the parties, meaning the employer and the exclusive bargaining representative, in their collective bargaining agreement in a no strike, no lockout clause, which means that they promise that in the entire duration of the CBA, there will be no strike and there will be no lockout conducted. Now the question is, are these agreements valid? We have to qualify. No strike, no lockout clause only applies when the reason for strike would be economic strike. But if the reason for strike is unfair labor practice, notwithstanding the fact that there is a no strike, no lockout clause in the CBA, the employees may still be able to strike and the employer or the company may still be able to declare lockout. I think the reason for that is that if the reason for strike is economic, then parties are allowed to bargain away their rights. But if the reason for strike is unfair labor practice, which is criminal in nature, no amount of agreement between the parties will be able to waive that ability to declare strike or establish a lockout. The next item that we must consider would be purpose. Note that for strikes or lockouts, there are only two kinds of purposes that will be allowed for the declaration. Number one would be economic deadlock during bargaining, or number two, when unfair labor practice has been committed. If there are other reasons for striking or for declaring lockouts, then the strike or the lockout will be considered illegal. The fifth item to consider is whether the employees declaring strikes are prohibited from holding a strike. Under current laws, only one group of employees are not allowed to strike, and they are government employees. The last item to consider is procedure. The procedure in declaring a strike or declaring a lockout must be strictly complied with. Failure to comply with the procedure will render the strike or the lockout illegal. So for example, if a labor union declares a strike, the first thing that they have to do is to file a notice of strike before the National Conciliation and Mediation Board. In the notice of strike, they are required to state the reason for strike. It is either, as mentioned a while ago, because of bargaining deadlock or because an unfair labor practice has been committed against them. This item in the notice of strike is important because we will see that it will have an effect on the next step of the procedure, which is called the cooling off period. The concept of cooling off period means is that when the union files a notice of strike, they must wait for a certain period of time before they can actually conduct the strike. If the reason for striking is economic deadlock, the cooling off period is 30 days. If the reason for this strike is unfair labor practice, the cooling off period is 15 days. But if the reason for striking is union busting, meaning the officers are being terminated, then there is no cooling off period. The next step in declaring a strike would be to get the strike vote from the members of the union. Note that before a strike vote can happen, there is a requirement that the exclusive bargaining representative intending to conduct the strike vote must send a notice to the National Conciliation Board 24 hours before the strike vote can happen. This is a requirement so that the NCMB officials would have an opportunity to observe the strike vote. Note that it's just an opportunity as long as the notice has been sent 24 hours before the strike vote. Even if the members or the officers of the NCMB do not attend the strike vote, the unions can still continue with the strike vote. In a strike vote, majority of the general membership of the union must vote to have a strike before that particular union can validly declare a strike. After the strike vote is conducted, the vote results must be submitted to the NCMB for confirmation or validation. From the time that that notice is sent to NCMB, a strike may only be conducted 7 days therefrom. In other words, the union will not be able to conduct a strike prior to the lapse of that 7-day period. So if you will mesh the cooling off period and the 7-day strike vote, there will be some complication. You will note that in the cooling off period, when the reason for striking is union busting, there is no requirement of cooling off period. In other words, the cooling off period is 0. But in this particular instance, even if the reason for striking is busting the union, that particular union must still observe the 7-day period of notification for strike vote. Now, what will happen if the strike vote happened or conducted during the cooling off period? Will the 7-day period run simultaneously with the cooling off period, or the cooling off period must end first before that 7-day period to run? There are conflicting views. For Professor Azucena, who is a well-known author of labor laws, citing the opinion of the NCMB in its primer, Professor Azucena is of the opinion that before the 7-day period could run, the cooling off period must expire first. In other words, if the cooling off period is 30 days, even though the strike vote happened in the middle of that cooling off period, you have to wait for the expiration of the entire 30-day before you make the 7-day period run. So in total, there will be 37 days before the union can actually conduct the strike. There are some authors and some authorities in labor law which says that when the strike vote happened in the middle of the cooling off period, those periods are allowed to run simultaneously. Anyway, their purposes are different. Once the cooling off period and the 7-day period expire, that is the time that the union can actually conduct the strike. Note that failure to meet or to comply with any of the procedural requirements in declaring strikes or lockouts will render the strike or lockout illegal. Note that there is a doctrine of good faith strike, which means that even when there is a finding of the court that there is no unfair labor practice committed, but the employees which conducted the strike truly believe that an unfair labor practice was committed against them, the strike that they conducted will not be considered illegal. Note that this doctrine is not applicable in failure to comply with the procedural requirements. In other words, the moment that the striking union fails to comply with any of the procedure, that strike will be considered illegal. Now, what is the effect of illegal strike to employees? It depends. The rule will be different with respect to union officers and union members. If you are a union officer and you knowingly participated in an illegal strike, it is possible that your employment will be terminated. But if you are a mere member of a union, mere participation in an illegal strike will not cost you your employment. What will cost your employment is if you commit an illegal act during the strike. That is why it is important to consider, as I mentioned a while ago, that failure to comply with the injunction issued by the Secretary of Labor would be considered as an illegal act. In other words, even mere union members who fail to return to work despite the order of the Secretary, they will be considered to have committed an illegal act and therefore their employment may be terminated. In summary, in considering the legality of strike, one may consider 6 items. The first one would be the means and method employed. The means and method employed should be lawful. Otherwise, the strike may be considered illegal. The second would be the injunction issued by the Secretary by assuming jurisdiction over the case or certifying the matter to the NLRC for arbitration. The third one would be the agreement of the parties, if there is a no strike, no lockout clause in the collective bargaining agreement. The fourth one would be whether the employees who are declaring strikes are prohibited from doing so. The fifth one would be the purpose of the strike. As we noted, there are only two purposes. One would be deadlock in bargaining or the commission of unfair labor practice. And finally, the procedure. The procedure must be faithfully complied with so that the strike will not be considered illegal. In the next episode, we will be discussing termination of employment.